Sean todos bienvenidos hoy, 17 de septiembre, a una nueva sesión de nuestro comité de arbitraje aquí en la Cámara de Caracas. Hoy estamos, la verdad, muy emocionados por estos expositores de primer nivel que nos ha preparado el comité de arbitraje. Pero bueno, antes de iniciar, les recordamos a todos seguirnos en nuestras redes sociales, @Cámara de Caracas en Instagram y X, y también nos pueden encontrar en LinkedIn como en la Cámara de Caracas. Les recordamos que van a tener disponible el chat en vivo para realizar todas sus preguntas y planteamientos. Y asimismo les recordamos que esta conferencia va a estar siendo en el idioma inglés, pues traemos a nuestros invitados desde Singapur. Entonces, bueno, ya para no alargar muchísimo más esta presentación, damos espacio al señor Ramón Escobar Alvarado, presidente del Comité de Arbitraje.
Buenos días a todos. Es para mí un grato placer hacer otro comité de arbitraje, esta nueva sesión. Debido al contenido de la sesión y a nuestros invitados, vamos a hacer esta sesión en el idioma inglés, entonces voy a pasar a hablar en inglés. Good morning to all. It's a great pleasure commencing this new session of our arbitration committee. It's a double for me. It's a double pleasure. First hand, because it's always great to dedicate or focus one morning to speak about arbitration, to develop or help to develop an arbitration culture in our country. And second of all, because of what we're going to speak today, no? We're going to speak about the importance that Singapore and Singaporean law has in international commercial arbitration. Singapore is one of the top seat of arbitration. Its law its domestic and international law are pro arbitration, and recent experience that I've had has permitted me to see in practice how does arbitration works in Singapore, and I'm really delighted. For me, it was a really life-changing experience. I always put as an example of what are the drafters of our arbitration law and the people that also drafted our arbitration treaties, who had as an objective. I always I always say, metaphorically speaking, that they fought about Switzerland, that Venezuela should be a kind of Switzerland of Latin America, where everybody, or all people from the regions or corporation from from the region, came to Venezuela to settle their dispute in arbitration in Venezuela. Switzerland was therefore like the dream, the objective. After my experience in Singapore, I can say that I was wrong. Our objective should be Singapore, not Switzerland. Part of that is gonna be explained, or part of the reasons that led me to that conclusion is going to be are going to be explained by our panelists today. His name is Elan Krishna. Elan is a great lawyer from Singapore. He has a master at NYU Law. He's currently a partner in the great law firm of On and Basul. He's actually the head of a commercial arbitration department of that law firm. Alan has previous experience working in the most one of the most prestigious law firm of the world, and he has worked in Paris and London, and if I'm not mistaken, also in New York. Eland has also experience with arbitration all over the world, including Venezuela. Elan also is a member of the Law Society of Singapore Inquiry Committee. He's also an accredited fellow with the Chartered Institute of Arbitration, and is also a South Asia representative for ICC Young Arbitration and ADR Forum. I've had the privilege to work with him, and I can say that is one of the brightest and international lawyers that I have been able to work with. It has been a privilege to work with him, and moreover, I want to stress this, it is a privilege and a great satisfaction to call him my friend. Ilan, it's an honor for our chamber to have you here to speak about the arbitration in Singapore. Go ahead, Ilan.
Thank you, Ramon. Good morning, everyone, and thank you for joining us today. It's really my pleasure to be with you here today to talk about arbitration in Singapore. And I'm also very happy to be with my dear friend, Mr. Ramon Escobar. So thank you, Ramon, for helping set this all up. Thank you as well to the Caracas Chamber of Commerce for this very kind invitation. And in this presentation, I will try and highlight some of the reasons why I think Singapore has emerged as a leading seat of arbitration globally. And more importantly for the listeners, this will hopefully help you when advising your clients as to the potential options out there in terms of arbitral seats and institutional rules. Right. So over the next hour or so, we'll try and explore some of Singapore's key advantages from its neutral, business-friendly legal framework, as well as its world-class arbitration institutions. And we'll also try and compare them with some of the major arbitration hubs in the region, like Hong Kong and Dubai. So maybe let's start with the fundamental question. Why Singapore? So if you can see my background, my virtual background behind me, that's really Singapore. It's a really small country, 6 million people, no natural resources. It's so small that you can drive across the whole of Singapore in 45 minutes. That's all there is to this island. And if we look maybe at a brief history of the country, Singapore only gained its independence in 1965. So that's 60 years ago. And so by all accounts, we are still a really, really young country. But before that, we were a British colony, which explains why all of us have English as our first language. And that's really benefited us in many, many ways. But 60 years ago, whatever you see behind me in my virtual background, it didn't exist. Singapore was a small fishing village. That's really what it was. But we were lucky in many ways because we had a very, very strong government. It was led by our first Prime Minister, Mr. Lee Kuan Yew, who some of you will no doubt know. And because of him and his contemporaries, Singapore quickly developed into an Asian financial powerhouse with world-class infrastructure by any measure. Many of you will be familiar with Singapore's Changi Airport and Singapore Airlines, which are often ranked as the #1 airport and the #1 airline in the world. And so we have come very far and very quickly. Now, I think there are several things that make Singapore special, special especially when you compare Singapore to its neighbors. Number one, we are a multiracial, multi-religious meritocracy. So we have people of different races, different religions in Singapore, but there is no one dominant race, no one dominant religion. Number two, we believe in the rule of law. So whether you are a minister in the government or an ordinary person on the street, you are treated in the very same way in the eyes of the law. So that's number two. And number three, we have almost zero corruption. And that is why so many people want to do business in Singapore. Now, let's come on to arbitration, which is really the focus of today's presentation. Why Singapore? If you look at the slides, Singapore is now recognized as one of the world's top arbitral seats. In the latest Queen Mary survey, 2025, Singapore is ranked as the second most preferred arbitral seat in the entire world, only behind London. Now, Singapore ranks even ahead of Paris, which is the home of ICC. And I think what is probably more interesting is that back in the 90s, which is not such a long time ago, arbitration wasn't even a thing in Singapore. But then, 20 years ago, the government decided that Singapore should become a dispute resolution hub. Singapore was already an Asian financial powerhouse. We had traders, we had banks, we had MNCs, all with a substantial presence in Singapore. And so the government said, let's develop our infrastructure, let's develop our institutions so that all these parties can resolve their disputes in Singapore using confidential arbitration. And today, we are number 2 in the world. And so again, we have come very far, very quickly. Now, I said earlier that Singapore has a reputation as a neutral, stable, business-friendly jurisdiction with a robust rule of law. Now, what I mean by that is that the courts and the judges are completely independent. And this neutrality is a major draw for international parties. Now, when it comes to enforceability, Singapore has been a signatory of the New York Convention since 1986, which means that arbitral awards in Singapore are enforceable in over 170 countries worldwide. This global enforceability, coupled with Singapore's strong rule of law environment, gives parties certainty, right, that their arbitration agreements and their awards will be upheld and respected abroad. And as legal counsel advising our clients, that's one of the foremost things that we look for when we think about where we want to seat our arbitration. Now, beyond enforceability, Singapore's judiciary is exceptionally pro-arbitration. The courts in Singapore, they adhere to a policy of minimal curial intervention, which means they rarely, if ever, interfere in arbitral proceedings or arbitral awards. I think a way to describe it is to say that they see their role essentially as supportive or facilitative rather than purely supervisory. The courts are known to facilitate arbitration, for example, by granting interim measures or enforcing awards. But generally, they are hands-off when it comes to arbitration. They've repeatedly said, the Singapore courts, that they will not lightly interfere with arbitral awards. And the whole purpose of that is to reinforce finality in dispute resolution. Now, what does this mean for businesses? This means that businesses have confidence. They can have confidence and they should have confidence that an award obtained in Singapore will not be easily derailed by local challenges. Now, this is quite different from other jurisdictions. I do a lot of work coming out of India, and I've seen many, many cases where the local Indian courts interfere very actively, even where the parties have expressly agreed to submit their disputes to arbitration. So, for example, for many, many years, the Indian courts have consistently held that allegations of serious fraud are non-arbitrable and needed to be determined instead by litigation in the Indian courts. Now, what else sets Singapore apart? What is crucial, I think, is that Singapore offers a comprehensive arbitration ecosystem. We have a deep pool of experienced arbitration practitioners. You have counsel, you have arbitrators, and expert witnesses from Singapore and around the world who call Singapore their home. You also have one of the best arbitration hearing centers in the world, Maxwell Chambers. There's a picture of that on the slide. Now, this set of chambers was custom built to host multiple arbitration hearings at the same time. And I'll speak more about this shortly. If we can go to the next slide, Sabrina. I want to quickly touch on point number 6 as one other reason which sets Singapore apart from so many other seats. And that is the fact that we have a very strong homegrown arbitration center, the SIAC, which I'm sure many of you have heard of and used before. Now, again, back in the 1990s, no one had even heard of the SIAC. But today, it stands as one of the top arbitral institutions in the world, and it's one of the ICC's biggest competitors. Now, I talked a little bit earlier about Singapore's neutrality, and let me just pick up on that. Now, Singapore has always been close to the United States because of its military support in the region. On the other hand, Singapore has also always been close to China because of its trade ties, as well as the fact that 70% of Singaporeans are ethnically Chinese. But that being said, Singapore has always tried to take a neutral, principled approach in international affairs. In recent times, we've criticized the Chinese government because of its aggressive behavior in the South China Sea. And so I would say that you take from that the rule of law is central in Singapore. Just because we rely on certain countries for defense and trade does not mean that we will not stand up for what is right and what is principled. And finally, I come back to this point. The fact that Singapore is the least corrupt country in the Asia-Pacific region means that parties arbitrating here can be assured that when they do come to Singapore, they will be given a full and fair hearing. When you arbitrate in Singapore, you benefit from a system that is predictable, that is efficient, that is user-focused, and that is fair from start to finish. Now, again, not many jurisdictions can offer this. In many places, it really is a question of whether you know the judges and whether you know the ministers that determine the outcome of your dispute. That is not the case in Singapore. Now, if we can go to the next slide, Sabrina. Thank you. And that's the entrance of Maxwell Chambers that you see on the screen. Now, Singapore's preeminence on the international arbitration stage is, I think, borne out by the fact that many leading arbitral institutions have established offices here. You have the ICC, you have the ICDR, and more recently, ICSID has set up an office in Singapore. Now, to me, this is a strong statement. These globally known institutions, they've chosen Singapore as their base to serve users in the Asia-Pacific region precisely because they recognize that Singapore is a strong arbitral seat. What that means, the fact that you have these offices in Singapore, is that if you want to arbitrate, say, under the ICC rules with a Singapore seat, you have an ICC case management office in Singapore, which is administering that case locally. So you can call up the local case officer at the ICC during business hours and say, can you please tell me what is the status of my case? When will it be moving ahead? And to put this in perspective, there are very few other cities in the world that host offices of so many major arbitral institutions like the SIAC, like the ICC, like ICSID, like the ICDR. Now, I want to go on to the next slide and touch a little bit on the Latin American connection with Singapore and with Southeast Asia. Now, in the last 5 to 10 years, there has been significant and growing trade between Southeast Asia and Latin America. Now, the numbers on the slide tell their own story. Trade between Southeast Asia and Latin America, it runs into the tens of billions. Trade with Brazil, 34 billion in 2022. With Argentina, 9 billion 2023. Chile, 4.2 billion 2023. And Mexico, 2.6 billion in 2022. Now, with these deepening economic ties, disputes, as we all know, will inevitably arise. And so parties will have to find a neutral third-party country venue to arbitrate those disputes. And according to the 2025 Queen Mary survey, Singapore ranks now amongst the top 5 arbitral seats for Latin American respondents. Now, just let that sink in for a while. If you consider the geographical distance between Singapore and Latin America, the fact that it is one of the top 5 preferred seats for Latin American parties is remarkable. It really underscores the fact that Singapore has gone truly global. And you might ask yourself, why would a Latin American company and a Southeast Asian counterpart choose Singapore over a more traditional seat, say New York, Paris, or Geneva? And I think the answer to that question really comes back to what we talked about a bit earlier: neutrality, enforceability, and efficiency. Singapore, I think, offers a politically neutral venue that neither side can perceive as the other's home turf, as we like to say. Now, apart from that, Singapore is also obviously a convenient travel hub. I talked about Changi Airport at the start of my presentation. The airport has excellent connectivity and amenities for visiting parties. And Singapore is also known for having speedy, cost-effective proceedings compared to some of the other Western forums. I think it's also worth noting that Singapore's arbitral institution, the SIAC, has very actively engaged with its Latin American stakeholders. It's conducted outreach, signed various cooperation agreements, and this in turn has built comfort, it's built awareness. So as a result, when a Venezuelan seller and an Indonesian buyer, for example, need to agree on a disputes forum, Singapore frequently comes up as an acceptable compromise for both sides. Now, Ramon and I were working fairly recently on an arbitration together. We were acting for a Marshall Islands shipping company against a very large Venezuelan state-owned entity. The amount in dispute was $60 million US, and the parties chose Singapore as the governing law, and Singapore as the seat of arbitration. There was no real reason for the parties to choose Singapore as the governing law or Singapore as the seat. It had very little to do with Singapore, this entire dispute. But the parties recognized that Singapore as a governing law would be easily understandable by both sides, it would be fair, and Singapore as a seat would make a lot of sense for all the reasons we've just been discussing. And fingers crossed that arbitration will go our way. Now, if we go to the next slide, this hearing that I was just talking about involving the Venezuelan state-owned entity, it took place in Singapore at Maxwell Chambers. Maxwell Chambers is the world's first integrated dispute resolution complex. And it really provides a one-stop hub that combines top-notch hearing facilities with office space for arbitral institutions and services, as I mentioned a bit earlier. If you look at the slide, you'll really see a venue where you can have your arbitration hearing in a state-of-the-art hearing room. You have breakout spaces for each party. You have on-site transcription, interpretation services, and high-speed connectivity for people who are dialing in from abroad. In our case, we had an expert witness dialing in from Venezuela. And just down the hallway, as I mentioned earlier, you'd find the offices of the SIAC, the ICC, and ICSID. Now, Maxwell Chambers was opened in 2010. It was purpose-built by the Singapore government, and the whole reason for that was to support arbitration and alternative dispute resolution in Singapore. And today, in that short span of time, 15 years, today it is recognized as one of the top venues to conduct an arbitration hearing anywhere in the world. So now, if you were a client or you're a lawyer representing a client, the practical benefit to you is that you have a seamless hearing experience. If you fly into Singapore for an arbitration, Maxwell Chambers will ensure that you can focus on the case, while all the logistical and administrative aspects will run smoothly in the background. I think this is a concrete example of Singapore's commitment to being the best equipped seat of arbitration in the world. And maybe I'll just pause at this moment and invite Ramon to share a bit of his experience with that arbitration in Singapore and the arbitration being conducted specifically in Maxwell Chambers. Ramon?
Yes, thank you, Ellen. For me, as I said earlier, it was a really life-changing experience. For everything, from the human side, from the obviously the law side. I've been since I was 24 years old working in arbitration. I work in Paris. I have had the chance to work in Miami, New York, and other countries around the region. And my experience in Singapore was by far the best. From the law perspective, as you said, Maxwell Chambers, the level of and preparation of the expertise of the lawyers, also the sophistication and practicability and efficiency of the law, from both for law substantive and procedural law. But for us Venezuelan, you don't need a visa to go there. You just have to notify the government. It's really neutral in the sense that there's not a political bias as you find, for instance, in the US. And that's really important if we want arbitration to be really a neutral mechanism to resolve dispute. From there's the human side, no? For instance, that the immigration was done by a robot. Then I only saw one policeman during my trip in 10 days. I think I was there 10 days. Only one policeman, and that policeman was also a robot. So for us, we always say there's a huge gap between for Europe, the US, and us. In but I after that trip, I found out that that same gap between what we say exists between us and Europe and the US is the same gap that exists between the US and Singapore. For me, again, that's the human part. The law part was, again, amazing. The expertise, the high level of the arbitration expert as you, and all of our viewers can see that the way you speak, the your top ideas, everything. So for me, it was really a pleasure and a great gratification. So I would recommend everyone to have that experience, and I think it's we're gonna be better off than going to of having the same arbitration in the U.S., Miami, or even Europe. Cost-wise also. Maybe the trip there is not very expensive. Hotels there are less expensive than, for instance, Europe or New York, and cost efficient. I know that the law firms do not charge as much as a New York-based law firm. So that's something that we always taking into account, and it's also part of the equation in favor of Singapore.
Thank you, Ramon, for that. Now, you touched on the law in Singapore, and if we can maybe move on to the next slide. One more down, Sabrina, please. Now, I wanted to touch on Singapore's pro-arbitration legal framework. And this is really the backbone of why Singapore arbitration works so well. Now, at the core of this is the International Arbitration Act in Singapore, which applies to all international arbitrations seated in Singapore. The IAA, as we like to call it, it incorporates the UNCITRAL model law as part of Singapore law, which means that our statutes reflect internationally accepted principles. Now, the IAA and its related legislation, it's been very carefully refined over the years with input from practitioners and academics to ensure that best practices are adopted by the Singapore courts. So, for example, when you're talking about things like provisions on confidentiality, enforcement of awards, and court interim measures in aid of arbitration, the IAA has been continually refined to make sure that it represents international best practice. Now, aside from the law, the judges are perhaps even more important. And in that regard, the judiciary in Singapore has a very well-earned reputation for being arbitration-friendly and efficient. Now, arbitration matters are generally heard by high court judges who have very deep experience in arbitration law. Many of them were arbitration practitioners themselves before going to the bench. And the courts here, they really do respect party autonomy and the finality of awards. The judicial philosophy, which has been consistently reiterated in judgments over the years, is that arbitration is a private dispute resolution process, and court intervention should be a last resort and only in exceptional circumstances. Now, what does this mean in practice? What it means is that you have very narrow grounds to set aside awards or to refuse enforcement. And it also results in procedural decisions by the courts that facilitate rather than hinder arbitration. Now, to highlight the contrast, in some jurisdictions, parties often worry about unpredictable court interference or delays. I talked about India a little bit earlier in my presentation, but in Singapore, you can be very confident that the courts will not derail your arbitration on the grounds of some technicality. Now, in addition to that, I think this is important as well, Singapore has virtually eliminated the risk of home court bias. Even if one party is Singaporean and the other is foreign, the courts treat both with equal fairness. And just as important, foreign counsel are allowed to appear in arbitration-related court proceedings in Singapore with the permission of the court. Now, what that means is that everyone will feel that they are on an equal footing. It is a level playing field for everybody, whether you're a foreign party or whether you're a domestic Singapore party. Now, if we just go on to the next slide, Sabrina, I wanted to examine very briefly a few facets of the pro-arbitration legal stance in Singapore. Now, first, arbitrability. What types of dispute can be resolved by arbitration? Now, the Singapore courts take a very broad view of arbitrability for commercial matters. It is almost impossible to argue that a dispute is non-arbitrable under Singapore law. So it would only be in a situation where arbitrating a dispute would be contrary to public policy, for example, certain family law or criminal law matters, which is the case in most jurisdictions anyway. So now, even areas that were once sensitive, like disputes involving allegations of fraud or competition law issues, those are generally considered arbitrable by the Singapore courts as a matter of Singapore law. Now, what does that mean for clients? What that means is that you can comfortably draft an arbitration clause covering all disputes arising out of or in connection with your contracts. And you can be confident that Singapore law will give effect to that intent, except in the most extreme of situations. Now, if we go on to the next slide, I want to quickly touch on public policy.
Sabrina, la próxima lámina. Eso, gracias.
Thank you, Sabrina. Now, as many of us will know, the argument of public policy is often a last resort for a party that has lost in an arbitration and is trying to challenge an award. Now, in Singapore, the courts have taken a very narrow definition of public policy, both in the context of setting aside and resisting enforcement of a foreign award. Now, what does narrow mean here? Essentially, an arbitral award will violate Singapore's public policy only if upholding it would shock the conscience or violate Singapore's most basic notions of morality and justice. So just because an award is unfavorable or even legally or factually wrong does not make it contrary to public policy, right? So again, this serves the purpose of achieving finality in the dispute resolution process, because you don't want cases that go on and on and on. You need to draw a line in the sand, and the Singapore courts have been quite clear that they will not easily allow arguments of public policy to prevent the enforcement of an arbitration award rendered in Singapore. So I've just put on the slide very quickly some instances which losing parties often raise as arguments to found a public policy challenge. Just taking number one, for example, errors of fact or law by the tribunal. the Singapore courts have made very clear that even if an arbitrator gets the law wrong or misapprehends the facts, that is not a basis to annul an award on public policy grounds, right? So in summary, I think Singapore's message to arbitration users is this: we respect your decision to arbitrate. We won't let routine complaints or minor procedural issues overturn the outcome. So by closing that particular door, Singapore ensures that when you win an arbitration in Singapore, that award will almost certainly stick. Now, I want to draw a little disclaimer to that. And if we go to the next slide, I said earlier that Singapore courts will seldom interfere with arbitral awards. But I should say that one ground that they will consider seriously is a breach of what we call natural justice. And essentially, this means fundamental procedural fairness in the arbitration. Now, even here, the threshold to set aside an award for breach of natural justice is very high. The court will ask you specifically, which rule of natural justice do you say was breached? How was it breached? How is the breach connected to the award? And how has the breach caused actual prejudice to the party concerned? So it is a high standard. But I think the fact that the Singapore court will look at this issue of natural justice very carefully, it should also give parties some comfort that if you are the party that has lost in the arbitration, and that's because the tribunal has behaved very poorly or has not given you a fair chance to be heard, the Singapore court will look at that very carefully to determine whether or not the arbitral award should be set aside. All right, if we go to the next slide. Now, I want to talk about the SIAC because I don't think any presentation on arbitration in Singapore would be complete without talking about the SIAC. It is our homegrown institution and one that we are very proud of, and I think rightfully so. Now, according to the 2025 Queen Mary survey, as you'll see on the slides, the SIAC rules are among the 5 most preferred sets of institutional rules globally. So we are in the same league as the ICC, the same league as the LCIA. And in fact, the SIAC in recent years has been ranked as the most popular arbitral institution in Asia, and second globally, as you see on the screen, surpassing much older institutions which have a much longer and much more storied history. Now, why is this? And I think it really boils down to the fact that the SIAC is constantly innovating. It pioneered the emergency arbitration provision as early as 2010, before many other institutional rules. It also was one of the first to introduce an expedited procedure to ensure that for smaller value claims, you could have an award within 6 months. And that has proven to be very popular. And in terms of case management as well, the SIAC is often frequently praised for quick turnarounds on things like arbitrator appointments, and the fact that it has generally lower administrative fees compared to some other institutions. That's a big plus for many clients. All right. Now, if you go to the next the next slide, you'll see some of the stats, and I think these are really impressive, and it really bears out how far the SIAC has come. If you look at this, the stats for 2024, 625 new cases, and the total sum in dispute was almost $12 billion US. And so the SIAC, I think, is indisputably one of the top arbitral institutions in the world as we speak. Now, I think one other thing to highlight as well is that Singapore and the SIAC have never been content to rest on their laurels. We are always trying to get better, always trying to improve, always trying to find ways to innovate. So the SIAC recently issued its 2025 rules, its latest version of the SIAC rules. And if you go to the next slide, there's some useful features that I just wanted to quickly touch on in this presentation. Sabrina, if we go to the next slide, please. All right. Now, one of the new features of the SIAC Rules 2025 is the streamlined procedure. Now, this is for disputes under $1 million US. And essentially, the arbitration will be done on a documents-only basis, and you will have an award within 3 months of the tribunal's constitution. I think most of us know that many clients they're concerned. They don't want to spend so much money on legal fees and paying institutions when the amount of the dispute is not particularly large. And so the SIAC has responded to this feedback, and it's come up with a quicker, cheaper procedure for the lower value disputes. And again, the focus is really on efficiency and finding a solution that fits the needs of the clients. Now, I'm just conscious of time here, and let me just move on to a couple of slides down to talk about some of the recent themes and trends in Singapore arbitration, because I think this will be useful for members of the audience. Now, number one is procedural fairness and reason awards. Those really remain the focal points for setting aside applications. So whenever someone is trying to set aside an award, that's really what they focus on. Has there been procedural fairness? Has the award been reasoned? Now, parties have tried to set aside awards claiming they weren't given a fair opportunity to present their case. And the Singapore courts, again, while emphasizing the importance of natural justice, have generally upheld awards unless a clear violation is shown. The trend in the case law is an affirmation that there is really a high threshold for such challenges. Now, another aspect to that is arbitrators having to ensure that they write properly reasoned awards to avoid challenges. And here you have institutions like the ICC, like the SIAC, who pride themselves on a very strict scrutiny process. And they are the ones who really come in to make sure that any award that goes out in their name is going to be defensible and it's going to hold up if it's ever challenged in the Singapore courts. And as a result, you see many Singapore-seated awards that are very detailed. The arbitrators are trying to preclude any argument that an issue was overlooked, right? Because they really want to protect the award from being challenged. And if you go to point number 2, now you really have continued robust cross-border enforcement. So Singapore is and continues to be a jurisdiction where enforcement of foreign arbitral awards is routinely granted. And in the same way, Singapore awards are regularly enforced overseas. I think one interesting trend is of parties switching their preferred seats to Singapore for neutrality reasons. There are many companies that historically chose Hong Kong as a preferred seat due to familiarity or proximity to China. But many of these parties have been opting for Singapore as a seat in their new contracts. And the reason for that is Singapore is perceived to be geopolitically more neutral and more stable in terms of its legal framework. The Middle East is also another interesting area. While you have Dubai and you have Abu Dhabi, pushing as regional seats for arbitration, we still see many Middle Eastern parties, including state entities, more comfortable with Singapore as a neutral Asian venue for the arbitration, especially when you're talking about an Asian/Middle East transaction. And on point number 3, we're seeing a real mix of the arbitration disputes that are coming to Singapore. You have oil and gas, you have finance and banking, you have tech and venture cap. So I think what this means for clients is whatever industry you may be in, it's very likely that Singapore has handled similar disputes, and you will find arbitrators in Singapore who are familiar with that particular field. Now, let me just wrap this up very quickly with some practical takeaways. We've talked about Singapore's features as an arbitral hub and some of the recent developments in Singapore law. But what are the key practical takeaways that you can use as legal and corporate decision makers? And I would say number 1 is this: consider Singapore as a potential seat of arbitration in your contracts. If you're concerned about neutrality, enforceability of awards, and efficiency, and most of the times you would be, having Singapore as your seat is always a safe choice. It's a seat as well that both sides in the transaction can trust. If you and your counterparty are from different jurisdictions, Singapore offers a very neutral middle ground. And this can make your negotiations on your arbitration clause that much easier. Point number 2 is this: I would say leverage on Singapore's institutions and infrastructure. So tie in your selection of seat with the choice of arbitration institution, the rules. Now, the SIAC is an obvious front runner. Its rules are modern, and you have top-tier administration of those rules. So having an SIAC arbitration seated in Singapore is, I think, all round a strong option for most types of contracts. But in the same way, because you have the ICC, for example, on the ground, you can just as easily stipulate Singapore as your seat and provide for ICC rules to apply. That works perfectly well as well. And whichever way you go, in all likelihood, you'll want to conduct your hearing at Maxwell Chambers, and that's going to ensure that you have a high-quality hearing experience, which means you and your client can focus on the substance of the dispute and leave the administration, leave the technology to the experts at Maxwell Chambers, and they will take care of you. And the final thing I will say is this: draft your arbitration clauses as clearly and as comprehensively as you possibly can. Many of us will know that there are so many unnecessary disputes that arise because you have an ambiguous or poorly drafted arbitration clause. So while the Singapore courts will strive to do their best to uphold an arbitration clause, you can really save a lot of time and costs by getting it right when you're contracting at an early stage. So I really like the SIAC model clause, and for that reason, I've included this in the slide deck for your reference. I hope this presentation has been helpful, and I'm happy to take any questions you may have. And thank you once again to the Caracas Chamber of Commerce, my dear friend, Mr. Ramon Escobar, the distinguished members of the audience, and I'd like to say a special word to my colleague, Mr. Shazadul Haq, as well, who helped in putting together this presentation. I hope it was helpful, and I'm very happy to take any questions that anyone may have. Thank you.
Ilan, thank you very much for such a super excellent presentation. I'm really, really excited what I heard, the ideas, everything. And I'm really glad that I'm your friend. Very, very the superb presentation. Basically, some people have written me by WhatsApp and asked me to ask you some questions. The first one has to, there are like two sets of questions. The first one has to do with interim measures, no? And I explain. Basically, in recent years, the number of arbitration in Venezuela has increased. Why? Because for us, it's easier to have an arbitration, have an award, and then that award execute that award abroad. No, at the end is easier than having the whole process here. The execution process is here. Normally, a Venezuelan will go to the US or even Paris or London to execute, sometimes Spain. So my first question, why would you recommend them to go to Singapore? And I want to link that with the cooperations or the cooperation, if there's a link of cooperation between the arbitration community, the arbitration forum, the execution process, and maybe the banks, the financial sector in Singapore, that I know that it's basically one of the strongest in the world, which means that most of the banking institutions of the world have an office over there. So that's one question, the execution. Why a Venezuelan or two Venezuelan parties, or maybe one Venezuelan party with an international foreign corporation will execute its award, a final award in Singapore? That's question number one. Question number two will be the same thing, mainly the same thing, but with interim measures. Something that we found in this process of having executions in the US is that for an American lawyer, an American law judge, it's really hard to understand ex parte interim measures. So there's always they're not used to that, to having an execution of an ex parte interim measure. Whereas in Venezuela, I don't know the numbers, but if I have to give an estimation, that will be around 90% of all interim measures are ex parte. So why would it be better to have that interim measure executed in Singapore instead of the US or France? The other one, the third question, it's mainly a number that you said, the almost $12 billion in Singapore you said the
Amount in
number.
dispute.
Exactly. Per year or
Yeah.
in total? That's one.
No, just for that year.
Wow, that's amazing.
Yeah.
That's really amazing.
So,
And
Ramon, maybe let me take that the first two questions first.
okay, perfect.
So why enforce in Singapore? And what benefit is the fact that you have interim measures, and how is that going to be enforced in Singapore? And I think you hit the nail right on the head when you talked about Singapore's status as a financial hub. So we all know that when we are looking to enforce, you have to go where the assets are. So where does your respondent have assets? That's where you need to go and enforce your award, right? Or enforce your interim measures against if you're trying to freeze certain assets, right? And so I think where Singapore has really benefited from this is because of its status as a financial hub. you essentially have all the large financial institutions in Singapore. You've got all the large banks. You have, importantly, the large private banks in Singapore. So if you want to attach assets and if you're looking at bank accounts, there is a reasonably strong chance that the party that you're going against will have some assets in Singapore. Obviously, you will have to go through an asset tracing exercise to determine exactly where these assets might be. But once you've concluded that there are banking assets that you can attach in Singapore, it's very easy to go before a Singapore judge and say, I have this arbitration that's ongoing. I need interim relief in support of that arbitration. I want to make sure that the respondent is not going to dissipate the assets in the account such that there's no point to that arbitration anymore. Or conversely, at the end of an arbitration, you have an award. You take that award, you go to a Singapore judge and say, I want to enforce this in Singapore. Can I garnish this bank accounts, which is basically an attachment order that you will get from the Singapore courts? The Singapore judge will know exactly what you are trying to do, and you will get the relief that you need to make sure that your judgment, your award, is not just a paper award, but it's something that will actually allow you to collect some money against at the end of the day.
That's excellent. And how about interim measures?
Yeah, in the same way, right? In the same way, because if you go, what the Singapore court system allows you to do is that even for a foreign seated arbitration, even if you don't seat an arbitration in Singapore, if you are given interim measures by a tribunal overseas, you can still take that to the Singapore court and say, I need you to give me this attachment order against assets, because otherwise these assets are going to be frittered away and my foreign seated arbitration or my Singapore seated arbitration will have no point.
Okay.
And the Singapore court will look at that and say, yes, is there a real risk of dissipation? Has that been demonstrated to my satisfaction? If there has, there's no reason for me not to grant this award, not to grant this order to attach the assets. So the Singapore court likes to use this term called holding the ring. So essentially, they will hold the assets in place until a final determination has been made as to whether or not there is a valid claim or not in the arbitration.
No, excellent. My last question, I think the last question that we have due to time, it's I'm gonna link it with a comment. Uh, I really liked what your suggestion or your comments regarding that the something that has helped arbitration in Singapore is that you have a local arbitration center, really robust, really strong, and that it's second to none, and that has helped to grow an arbitration culture in Singapore. Here in Venezuela, we have a huge, really strong arbitration community. I do believe that most of the really important law-related studies and developments have come by means of arbitration. Young people that just study arbitration, young lawyers that practice arbitration. I think that's a fact and a really good one, a really good fact. And one way that the people that form this culture, this forum, this arbitration forum, believe that we can make arbitration stronger, have a better number of cases, is by means of having strong arbitration in centers in Venezuela. That's one way. That basically your conference, your presentation reaffirms that idea. What suggestions would you give to to another member, because you are part of our culture, of our forum, of our community, uh, what advice would you give to have a strong or increase our arbitration culture, our Venezuelan arbitration system, its power and also its inefficient nature?
Sure. I think one of the beauties of the international arbitration community is that people who are involved in arbitration and who are interested in arbitration are almost invariably the most open-minded, welcoming people that you know. I think everyone in the community is constantly curious, constantly trying to learn more about different traditions, different legal systems, how things are done. And from that, you actually you become so much more well-rounded, right? So I would say is speak to as many people as you can from different parts of the world. If you can work in in overseas offices, in a different legal tradition, common law, civil law, you learn so many different things, and you can see that the world is so diverse, and arbitration is practiced in so many different ways depending where you are in the world. And there's so much that you can learn, you can borrow, you can steal from different people. And it makes you, I think, on a whole, a much more complete arbitration lawyer. So that's
Okay,
what I would say.
but I have to ask you this last question. I'm sorry for the time, but I just ask you what we can learn from your experience. The next question and the last question, I promise, is what does Venezuelan arbitration has left you? What have you learned? What has our Venezuelan arbitration culture given you?
I mean, I've looked at some of the most important Venezuelan law judgments that have come out from the Constitutional Chamber. And I think it's very clear that Venezuela has a very strong pro-arbitration approach to things. I think that the fact that it's difficult to rely on domestic laws to defeat an international arbitration agreement, I think that's perfect. I mean that's completely in line with some what people would call the internationalists, someone like Gary Bond would say. So that's exactly in line with that. So I do think that there is already a very strong pro-arbitration culture in Venezuela. I think the judges are united in that stance, and I think the more the community in Venezuela starts taking ideas and learning from different parts of the world, even parts which are a little bit further away, I think everyone will be richer for it.
No, thank you, Ellen. This has been an amazing presentation. Shell, also thank you. We're really, really excited myself and also the Caracas Chamber of Commerce and all of the members of our strong arbitration community, which you two guys are right now part of. So, so
Thank you.
I know that it's gonna be the first of many. And thank you for spending this time at very late 9 o'clock in the evening for you with us in Venezuela and us in France. Thank you very much. Sabrina, I leave it to you.
Thank you very much for this presentation. Y a todos los que nos acompañaron a través de nuestra transmisión en vivo, muchísimas gracias por haberse conectado el día de hoy. También agradecemos al señor Ramón Escobar por habernos facilitado este espacio con estos expositores, bueno, con este expositor de la verdad primer nivel. Entonces, bueno, por acá en este canal de YouTube saben que siempre estamos desarrollando actividades, los invitamos a suscribirse, a activar su campanita de notificaciones, así les avisa cada vez que tenemos video por este medio. Y también nos pueden seguir en nuestras redes sociales, @Cámara de Caracas, en Instagram y X, y en LinkedIn como la Cámara de Caracas. Muchísimas gracias a todos por acompañarnos. Thank you very much to you too.
Thank you. All the best. Thank you.
Thank you.
Bye. Adiós. Hasta